Hello, everybody. Good to see you all out here tonight. Oh, Ava. Ava the Cookie Monster. Well, the Blue Buffalo Health Bars Monster. Look at her getting all excited. Look at her getting excited. I have the cases exporting right now. They're at like 35%. So it won't be very long, but when it's ready, you'll hear the dun dun wow. Hello, Jerry Matthew Boyd. Oh my goodness. 7 years is a long time for a battery. I think I usually get 2 or 3 out of mine. I'm sorry that happened to you. I had to DoorDash a jump starter pack one night because I had to go to Baraboo the next day. We got a snowstorm and my battery had died because the mechanic that I'd hired to fix something that's still not fixed, and I'm $400 deep that I've already paid him for his services of coming out here and everything, and yeah, he still hasn't fixed it, my blinker. And now he's saying it's a wiring issue. I'm like, I'm not paying you more money, dude, but you need to come fix this. Yeah, I'm not happy. Not happy at all. Hello, Manuel. Hello, Nana Laura, honey. Hello, C-Rex. Ooh. USA, USA, USA. Why am I not seeing Buzzy Pug and Auntie M, but I see people saying hi to them? Maybe, I don't know, maybe it loaded after, I don't know. Hopefully, Buzzy Pug and Auntie M, say something, please. Hello, Wire Mother. Hello, Richard Head. Good to see you. Happy birthday, Jerry! Do you want me to sing? Happy birthday, la 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 la. It's your birthday, yay, la 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 la. Earl's like, stop, Mom, just stop. Oh, it's Jerry's birthday and he got the kitties presents. He Discord messaged me and he told me that that he got them 80 licky treats. And that's actually kind of what they're wanting right now. But it's not time. Hello, Spider-Man. Hello, Joey Bag of Donuts. There she is. Hello, Auntie M. It's just StreamYard being goofy. If I miss anybody's comments, it's not on purpose. Hello, she's a maker, honey. Hello, Linda Applegate. Hello, Mortimer Duke. Hello, Eileen and Carlin. Hello, Buzzy Pug. Yeah, yes, 100%. And speaking of which, so my CapCut needed an update. That's why the export's not ready yet. And Earl decided to walk all over the keyboard before I could hit the export button. So if anything's moved out of place, it's Earl's fault. Told ya. Hello, Jenny Green Honey. Hello, Farkin the Stitch. And Earl and Billy. we got most of them here tonight. We got 3/5 of the PAWFURM. Hello, Salty Buddha. Yeah, right? No, that stopped off. Yep, I filled that before I got started. I love you, Buzzy Pug. You are such a sweetie, and I'm so happy to call you my sister. Oh my. You could have practically bought a new car for that. No. I bet it feels that way. I'm sorry. Oh my. An earthquake alert? Yikes, I couldn't even imagine. We've had blizzard alerts here, but we've never had an earthquake. Not in Wisconsin. Not that I know of. Well, I can't exactly do what I do on a tablet. I can barely do what I do on a computer. I actually think that I might get a second computer and have it set up so they're like together. So that way that I can edit cases on one and do downloads on the other all at the same time. And I could run 2 versions of CapCut at once. And then I could do Replay Crew mini videos on one and edit the cases for the evening on the other. Bottom line is it's really hard to do on one system. There's not enough hours in the day. Yeah. Mortified. No. I'm just kidding. Earthquakes happen all the time when I lived in the San Francisco Bay Area. Wow. Well, when I was a kid, I always heard California was going to have an earthquake and fall into the ocean. It never happened. Bye, Earl. I guess he realized he wasn't getting the treats yet. He'll be back. He'll be back. Right? And all the people that talked about, that it was going to fall into the ocean, or it was going to flood out within the next 10 years or whatever, they all bought property on Martha's Vineyard, so that didn't make any sense. Oh, my punny friend, I love you so much. Promise. Hey, man, the people of Northern California are amazing. Hello, Miss Epinette, honey. Oh, for your battery? Oh, that's awful that you have to have it shipped in. I'm sorry. Oh, wow. It was bad enough living near a train and the house would shake and rattle when the train went by. I couldn't imagine the earth literally moving under my feet. All right, guys. So I'm going to apologize in advance. The audio of this courtroom sucks. I did my best to enhance it. If it's still not good, blame Earl. But before we do that, Auntie M sent a case. So we're gonna watch one body cam video, courtesy of Auntie M. That is very, very mean. That's not nice. Not at all. All right. All right. Almost there. I have not seen this yet. But this is courtesy of Auntie M.
Hello, ma'am. Are you in this car? Yeah. I'm out with the driver now. Whose car is this?
My mom's. It's right here.
Negative. She's saying it's her mom's car, so we're working on it. Do you have ID on you?
Yeah.
Why would mom list it as stolen?
Oh, that's not my car. I'm sorry. Wait.
Ma'am,
yeah.
Stop.
Oh, I'm sorry.
It's your mom's car?
Yeah, it is my mom's car. That's her stuff in there.
Oh, okay. Do you have ID on you?
Yeah.
Let's start with that.
It was reported as stolen?
Yeah, why would mom list it as stolen?
I don't know.
Okay. Well, when I said it was stolen, you're like, oh, wait, this isn't the car.
Oh, my God. What's going on?
So the fact is, when I said it was stolen, you're like, oh, wait, this isn't my car.
No, I thought,
Hold on.
I'm visiting from out of town, and she just got this.
Okay, let's see the ID.
Yeah.
Oh, my word. Am I watching an old Cheech and Chong show? What is this gal smoking? This discombobulated gal doesn't know dilly squat. I bet she doesn't know a widget from a what-a-doodle either. So we have here today this saddle sliding out from under her lady that thought she was taking her mama's car to run errands. Well, lo and behold, she definitely wasn't driving her mama's car all around town. Watch as the hilarious details unfold.
how do you accidentally steal a car? This day and age. It must have been left running. And from what I hear, insurance doesn't like covering that if it gets wrecked from being stolen when you leave it running.
Even the cops were having a good laugh about it.
How long has your mom had it?
She's had it, actually my brother got it for her. She doesn't drive it that much. She's like 80 something. She doesn't get out that much. But she's had it maybe, gosh, about a year, I think.
Huh. Okay. And how long have you been driving it?
I just got here Friday.
Where'd you come from?
I live in Calabasas, California.
Okay. It's a little bit of ways away. And you just started driving it?
Yeah. I took I usually rent a car at the airport, but this time my brother says it's cheaper if you take an Uber and just drive her car while you're here.
Where does your mom live?
She,
Center in Technology. Charles Arbor Zebra 0566. Center in Technology neighborhood.
Does your mom know you have the car?
Yeah. I came here to get a battery for her garage door opener.
And your mom is the registered owner of the car?
I believe so, but my brother did it all. I could call him and what am I doing?
Let's make this really easy, officers. What's Mom's name?
They're looking into it right now to see where the mix-up may have been.
Here's her address. Yeah.
That's you.
8712 something. She lives right around the corner.
Yeah, 59th. Over in the apartments over there?
Huh?
Over by the apartments over there?
She lives in a home. It's a little gated community.
Yeah. That's weird. Okay.
This is the most excitement I've had in a long time.
You know, we aim to please.
Kind of anticlimactic.
Customer service is our middle name.
Yeah, wow.
What's the last sort of event?
Yeah, we just went grocery shopping, and then I had to get a new battery, and I just came over here.
Yeah. You guys, where'd you go grocery shopping?
At Fred Meyer's.
Up on Bridgeport?
Yeah.
Yep. That's why I've been coming in and out of town all day. Strange question. I got a mom too. How is your mother's mental health?
It's declining.
So, is there maybe a small possibility at some point in time you had the car and she could have woken up and been like, oh my God, my car's gone?
No.
No? Is there...
She's just a little, a little dingy sometimes. I think she'd just starting to get onset dementia.
Sure.
But she wouldn't do something like that.
Well, no, she wouldn't see the car gone and have a momentary lapse or something to think it had. Okay, so my partner's going to come talk to you. Obviously, this isn't Mom's car because I'm guessing Mom doesn't have a boy's name. This car was at Fred Meyer's and someone drove off with it. So, and there's video of it.
Did I take the wrong car? No. Oh my God.
How would you have taken
No, yeah, that wouldn't work, would it?
Well, ma'am,
Yeah.
hold on, listen.
No,
Listen, come out. Before the case officer comes up and chats you, I'm not writing anything. Okay, there's a big difference between being honest and taking responsibility for. Hold on, let me finish. and what's going on, okay? Because obviously, if this was, you're like, oh yeah, that's my mom's stuff in there, and everything like that. I'm guessing everything in there isn't your mom's stuff, since I just read who the RO is, the registered owner.
Okay.
So he's gonna. What's going on? Let's just be honest.
I'm totally honest. I don't know what you're getting at. I mean, I could have. The first time I drove the car was when I flew in Friday at night. The next morning, we had a bunch of stuff to do.
What's your brother's name?
John.
So where?
The one who gave you the car?
No, he didn't give me the car. It was parked at my mom's house. He got the car for my mom, but.
Where's the keys to the car?
It's one of those things that when you get in it, it automatically starts. Look at all these keys he has on here. And I went to get a battery. I had to get a new battery for a car because it wasn't working. Oh, God.
Tell me about your brother.
My brother, he lives up in Northern California.
I mean, to be fair, she's only driven the car once. She just flew in. So she's not exactly familiar with it.
Okay, I'm gonna hold on just for a sec. So here's a possibility. She's up from California. She borrows mom's car. The garage door has a label on it. Mom's car has a label, so she has these keys. She goes out from Fred Meyer's, gets in the car, drives off, and she's been driving this car ever since.
So she thought it was mom's car. Could happen. I mean, she doesn't.
I wonder if his key. You might want to ask her if she gets permission. You might find the other set of keys in the car, and that's why it keeps starting.
Yeah.
Because the keys are in the car.
I'm gonna guess that's very plausible.
Yeah, this doesn't even lock it.
You don't have to. I've been buying batteries for the garage.
Here's what I'm gonna guess. This is what I'm gonna guess. The owner of the car left the keys in his car. These keys don't go to this car. My guess is you hopped in the car thinking it's mom's car. His keys are in the car, which will allow it to start. Did you realize that the car isn't locking?
Yes, that's why I've been buying batteries.
Yeah, it's not that. It's because these keys don't go to this car.
So how can I? Where's her car at?
Your car is probably still at Fred Meyer's where you left it.
Today?
I think yesterday or today.
Accidentally stolen.
When did you go out from Fred Meyer's? Was it yesterday or today?
We've been going every day. Every time she needs something.
Did you find the keys? So his keys are in the car. You've been driving the wrong car for however long it's been. These keys are mom's keys.
Yeah.
They don't go to this car.
Oh, I'm so sorry.
Yeah.
Whoops.
Oh
my gosh. All right, well, maybe we can.
What is in the car that is yours? Hold on.
Her sunglasses and
Well, hold on. We'll grab it. What? Just tell me what.
see that thing that says gate.
The
on
gate?
it? Yeah, she needs that remote.
Okay.
We need to. Can we get her a courtesy ride back to Fred Meyer to get her car?
Yes, we will. We'll figure that out.
Oh my.
Oh,
I can't let you go in the car, man, but I can grab stuff out. Okay.
this is
And
mine.
these things,
This
who
is
can drive her up? Okay.
this,
You're gonna go with this. You said these are hers.
no.
Oh, but that's
No.
her. That's labeled just like your car
Yeah.
keys, so that makes sense.
Where do you think your car is at?
Fred Meyer somewhere.
It'll be close by the door. She doesn't like the door. So.
Fred Meyer by UP.
UP.
Right, I'm sorry about that.
Give that back to you.
Yeah, thank you. Thank you.
Yeah, it wasn't working, so she went to go buy it a battery. She's lucky she didn't manually lock the doors and not be able to get back into the vehicle. Oh my.
That was actually entertaining. So is he coming up to get his car?
He's gonna get the keys and get another person from the other side. He's coming.
Doesn't need the key.
Oh.
We're in the car.
Yeah.
No, I know, but he has to steal his girlfriend's
Back in the
car,
car.
so he can't take both cars home. So he's just gonna come here and get the keys, and then
Oh, and lock it up. Okay. Well, here I'll shut the door if you want to lock it. You have the keys, right? Oh.
Well, then it won't lock. I'll go to all others.
Oh my. Nice car.
Yeah. That
that a first for you?
Yeah, oh, absolutely. Almost awesome. That was fucking entertaining.
In the end, you guessed it. They figured out the situation and gave this lady a ride to her actual mama's car, which was sitting in the parking lot at another establishment. She sure got lucky. Back where I come from, they might not have let that explanation ride and would have still held her feet to the fire regardless. If you like what you're watching, we would be mighty grateful to you if you would go hit those subscriber, like, and share buttons harder than a raccoon in a trash can at midnight.
I am going to put the link for this video in the description of tonight's show because that was awesome. That was, I really like the narrator's voice. I agree with Salty Buddha on that one. And that was just hilarious. Wow. When I was a kid, so I grew up in Baraboo. We have Devil's Lake in Baraboo, and one of the big things is, walking around the lake, there was a trail on each side, North Shore and South Shore, that allowed you to walk completely around it, right? So there was my dad had to deal with Fords used to use, they had like 12 keys or something like that they would just, like, different batches would go to different parts of the country or something like that, and you could run into a situation where a key worked for multiple vehicles. But it was, what's the likelihood, that you're going to try the key in the correct ignition and it just happens to work? Well, it happened at Devil's Lake. Some guy he thought he'd made it all the way around. He saw his car in the parking lot and he hopped in and he's driving down the road and he's like, oh, that's not my sweater. Where'd that come from? And wait, these aren't my sunglasses. And so he pulls over and he calls the cops, and yeah, his vehicle was on the other side of the lake. And the key worked. So, yeah. That one got straightened out too, just like this lady. She's lucky she didn't get Grand Theft Auto charges. Am I? Dang it. Dag nabbit. It's not my camera, it's my internet connection. It's my Spectrum. And unfortunately, there's really nothing I can do about it. I've got everything turned off. I'm connected via the Ethernet cable. The only thing that I could do is reboot my router, but I'd have to start the stream over. Do you guys want to come back? I know. We don't have now, if they had fiber optic in my area, it wouldn't be a problem, but they don't. I agree. I'm not a fan. Let me close down. I'm going to close down all unnecessary windows. Okay. And that's part of it too. Yeah, we've had blizzards here for the last couple of days. It's so good to have you here, Island Lightning. Thank you. I'm sorry that my internet connection is subpar at the moment. It shows me full access though. Wait. Yeah, no. Hold on. Yeah, it's showing me that I'm good. I'll give you double the refund. How's that? Triple. Oh my. They upgraded me to a gig because I called and I asked if we had fiber optic here because Google says we do. And they said, no, we don't, but you can save $30 a month or something like that. Yeah, $30 a month and move up to 1 gig. And I'm like, well, we'll try it. Okay. The problem is when I start streaming the case, I don't know what that's gonna do because the upload. If it gets too bad, then well, and just so you know, the case picture is gonna be a little blurry, a little pixely, just as it is because it was really tiny and I expanded it, which I didn't think I was gonna have a problem. Hello, Metal Rules. I'm glad that it works for you. Trust me, I'm really glad it works for you. I wish it worked for me. He is Tech Kitty. The last I knew, I only had 20 megabytes per second upload. I don't know how many I have on the gig plan. It would only have gone up 10 to 20 more. Yay! See, we just needed to wait it out. All right, now that it's good, yay. Okay, now that it's good, now I'll put the case on. I love when you lie to me. All right. Do. Oh, wrong folder.
Are you Mr. Burgett? No, sir. All right, Mr. Burgett, we'll go on record in your file 21-10139 FC. You'd say Michigan versus Donald Allen Burgett Jr. And Agent Cornwell, are you on as well? Mr. Burgett? Okay. And you can hear me all right? Yeah, all right.
Agent Cornholio?
Mr. Burgett, you're here this afternoon as a result of a request for warrant for probation violation was filed by Agent Michelle Cornwell, who's also present. And it alleges that you are in violation of your probation. You're currently on probation to the court on a charge of assault with an intention to great bodily harm less than murder or by strangulation. And that if you were to be found guilty of the violation or to admit to that, the court could revoke your probation and sentence you to a term of imprisonment up to 10 years in the state's prison. You understand that? Okay. Now, the allegations that are set forth in the petition alleging count one, that you violated condition 4.25 of your probation when on or about November 14th. You violated probation when you failed to report police contact. And count two, violated condition 1.2, and that on November 25th, you violated probation when you had contact with minor children. Count three, you violated condition 1.3 when on or about November 25th. You violated probation when you were engaged in a romantic relationship with someone who has custody of minor children. In count four, you violated condition 4 of your probation when on or about November 14th. You violated probation when you changed your residence without permission of your field aide. In count five, you violated condition 2 of your probation when on or about November 6th. And November 14th, November 24th, and November 25th, you went to the state of Indiana without permission. And in count 6, you violated condition 6.4 when on or about November 25th of this year. This year, you violated probation when you failed to obtain verifiable employment. Those were technical violations of probation. She is also alleged you committed the following non-technical violations of probation, specifically in count 7, you violated condition 1. When on or about November 14th, you violated Indiana state law when you were charged with driving without a license. And count 8, you violated condition 4.6 of your probation when on or about November 6th, November 14th, and November 24th, and November 25th. You violated probation when you had contact with Violet Celine. As I've indicated, you are on probation in the court, and if you were to be found guilty of these violations, the court could revoke your probation, or upon a conviction, could also modify the terms and conditions of your probation.
That is a lot of violations.
In this matter, you do have the right to be represented by an attorney, Mr. Burgett, and if you could not afford an attorney, the court would appoint an attorney to represent you at public expense. You also are entitled to have a hearing in this matter if you choose. And so let me find out from you, do you wish to be represented by an attorney in this matter?
Your Honor, I'm sorry to interrupt. I've been assigned counsel, Your Honor.
Oh, okay. I didn't see order, at least copy here, but maybe there was copy. Pull it up. Okay, you got assigned. Have you had a chance to discuss that with him?
I have, Your Honor, and my clients indicated, and again, if I'm incorrect, Agent Cornwall, please correct me, but I believe my client will be taking responsibility for counts 2, which is the contact with the minor children, count 3, romantic relationship, count 4, changing residence from Michigan to Indiana, count 5, leaving the state of Michigan to the state of Indiana, and then count 6, the verifiable employment, and also count 8, contact with Miss Celine. He would be admitting responsibilities to those counts, with counts 1 and count 7 being dismissed. That's what I believe that we're going to be doing today moving forward.
All right. Let me just ask you, Agent Cornwall, before I turn to Mr. Burgett, is that what your understanding was today?
Yes, Your Honor. Thank you.
And you're fine dismissing the counts 1 and 7?
Yes, Your Honor.
All right. Mr. Burgett, then your attorney, Mr. Hogue, is present here in the courtroom. He's indicated that you were going to accept responsibility or plead guilty on the counts 2, 3, 4, 5, 6, and 8 charges that I went over. Is that what your intention is here today?
Yes, Your Honor. I've been here for
What's that?
28 days. Yes, Your Honor. I've been in 28 days.
Okay.
I'll be in the
Okay, but that's what you want to do here today?
Yes.
Okay, can you raise your right hand, Mr. Burgett? Do you solemnly swear or affirm on account of perjury that testimony you will give in this matter now pending before the court will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
Okay. You can put your hand down. Your name is Donald Allen Burgett Jr., is that correct?
Yes, Your Honor.
And you got a date of birth of October 18th, 1993.
Yes, Your Honor.
Now, Mr. Burgett, if I accept the pleas here today, we've already gone over what the potential penalties are. So I want you to understand as well that you're giving up the right to have a hearing by pleading here today. Do you understand that?
Yes.
Giving up a right not only to that hearing, but to be presumed innocent at that hearing, and to be presumed innocent until proven guilty of the charges by a preponderance of the evidence. You understand that?
Yes.
That means you'd be giving up the right to have the witnesses who accuse you of the charges to actually appear in court, testify under oath in front of you and Attorney Hogue. You're giving up the right as well to have Attorney Hogue question those witnesses on your behalf. You understand that?
Yes.
You'd also be giving up the right to present witnesses or evidence in your defense and to have the court issue subpoenas on your behalf at the request of Attorney Hogue so that you would have that opportunity. You understand you're giving up the right to have the court assist you and Attorney Hogue in that regard on your behalf.
Yes.
You also give up the right by pleading here today to remain silent, not have your silence used against you. Obviously, the court has to ask some questions, so you're giving up that right you would have in these proceedings and at that hearing to remain silent and not have that silence used against you. You understand that?
Yes.
And then you're also giving up the right as well, even though you'd be making some statements if you do plead, you'd be giving up the right you have at a hearing to take the witness stand in open court and testify in your own behalf if you wish. Do you understand you're giving up that right?
Yes.
Okay. Let me ask you, Mr. Burgett, has anybody promised you and then get you to plead to the violations here today?
No.
Is anybody threatening you in any way?
No.
Are you pleading then to these violations that we went over previously of your own free will because you believe you're guilty of the violations?
Yes.
Okay. So I'm going to ask you some questions then, Mr. Burgett, and let me just ask you, Agent Cornwell, have you spoken to Mr. Burgett, made any promises or anything regarding sentence or disposition here today?
No, Your Honor.
All right. Mr. Burgett, you're currently on probation in this court, correct?
Yes.
And you went over terms and conditions of your probation, probably with a prior probation agent, but Agent Cornwell is currently your probation agent. Is that correct?
Yes.
Now she says you violated your probation in count 2 when you had contact with minor children. Also in count 3, again violation of conditions 1.2 and 1.3 when you were engaged or were involved in a romantic relationship with someone that had a minor children, minor children. So why don't, and I'm assuming that might be the same individual. Was that the Violet Celine?
Yes.
And who is Violet Celine? She your girlfriend? Okay, and how long have you dated her?
I've been around for 12 years. So
Okay.
relation wise, I've been living with her for gone on 3 years.
Okay. And she okay, and so you weren't to have contact with her, is that correct?
Yes.
Okay, and then you also were not to have contact with children under the age of 17, and I'm assuming then that she has children under the age of 17, is that correct? I didn't hear you, is that correct?
That
Okay, and it also, then does she live in Indiana?
she ended up homeless and I moved her. Got hold of one of my cousins and to see if they could stay there with her. And so they could figure something out and I'll stay in their room.
Okay, was that in Indiana?
Yes.
Okay, and whereabouts in Indiana? Is it in South Bend, Elkhart, Mishawaka?
South Bend.
Okay. And then it sounds like you had contact with her a number of times. So we got the 6th, the 14th, the 24th, and the 25th that you left and went to the state of Indiana without permission. Is that correct as well?
When I absolutely needed to due to other circumstances.
Okay. Were you do you have employment?
Yes, I do.
Okay. And did you, the agent says that you violated condition 6.4 when on about November 25th, you failed to obtain verifiable employment. Were you employed then, or?
Yes, I ended up giving Miss Michelle a business card of my Florida guy I was working with at the time. His name is Justin Campbell, and he owns and operates himself his own business, which is Justin Something and that's big.
Okay. Let me ask you, Agent Cornwell. He's indicated he provided you with verifiable employment, or at least a card of an employer.
He did provide the card. I called the employer and they wouldn't call me back. I texted him as well and he wouldn't call me back. I wasn't able to verify it. And he wasn't, I don't believe, receiving a paycheck.
That's why the employer's not going to call back and verify employment. He's paying him cash under the table. He's not going to call you back and say, yes, I'm committing a crime too.
But maybe cash or a 1099, I'm not sure.
Okay. How were you paid by your employer then? Was it cash or?
It was a handwritten check straight from his company account. The last check I know I received was for $450.
Okay. Was he taking taxes and insurance and things out, or taxes and, you know?
All different. It's all 1099 moving.
Okay, so it was all 1099. Okay.
So,
All right. Do you know why he wouldn't have called back your probation agent?
I have no clue. He knows I did on and off with him over the past 3 years, and he knows that I'm on probation. So why he never reached out back out, I have no idea. I cannot speak for him.
Okay.
You know that so I had to go straight to work immediately to leave here.
Okay.
And that's it.
All right. And did you also change your residence without permission? Had you moved without notifying Agent Cornwall?
With that, I ended up homeless out here because my dad moved back to Indiana from Park Shore address, which forced my end up no longer having an address. I stayed out there in weather until it got too cold, which forced my hand to try to find somewhere warm. At the time, I really couldn't necessarily rely on my dad for a proper place to lay my head because I never know what his schedule is. And during that time, also, he was sick with the pneumonia as well. And which kind of also forced my hand because it's the only other place I know that I knew at the time that I could go to voice my cousins, which was where my other kids reside.
Okay, so the reason you didn't notify your agent is because that's where Miss Celine and the children were, and you knew you weren't supposed to be in contact with her or the children. Is that correct?
I notified her that I was homeless, and I made it at Ingrid's going. I was trying to find, proper and with shelter to go to. So I was letting her, and I was staying in contact with her. I just didn't let her know that I was from there.
Yeah, you didn't notify her that that you no longer had your residence on Park Shore either. Is that correct as well?
I did notify her. I notified her within the first week after my dad left, which was when I had my probation checking with her in person. And since I've been with Miss Michelle, I've had in-person check-ins once a month.
Okay. And so once you lost the Park Shore Drive address, you really haven't lived in any stable residence since then. Is that correct?
That's correct. And I was trying to find, get enough money to be able to get myself an apartment out here, or a hotel room or something. and I was literally about maybe $400 or $500 short for being able to get a hotel room for a month when I needed just understanding.
Only $400 or $500 short to pay for a month in the hotel. Only. But Judge, it's his father's fault. Didn't you hear? He was relying on his father for money, and it forced his hand. He said that multiple times. It forced his hand, and he ended up homeless. Maybe don't rely on other people for your income. I don't understand it.
Okay. Let me ask you, Agent Cornwell, did he advise you that he had lost his residence on 805 Farm Shore?
On December 2nd, he notified me of that and that he was going to provide his father's address and he wanted to transfer to Indiana to his father's address, but he did not ever provide that address. And yeah, that's when I found out he was living in Indiana.
Okay.
So he had an opportunity there to transfer, but he failed to follow through with it.
Okay. I don't have any further questions. I've got some concern on the failure to obtain or provide the verifiable employment. Sounds like he was working. The employer has contacted you back, and so I'm not going to find a violation of count 6, but I think there's sufficient testimony based on the other counts. So let me ask you, Mr. Burgett, as to that count 2, that you violated condition 1.2 on November 25th when you had contact with minor children, and count 3 that you violated condition 1.3 when you violated probation when you're engaged in a romantic relationship with someone who has custody of minor children. Count 4 that you violated condition 4 when on or about November 14th. You violated probation when you changed your residence without permission of your agent. Count 5 that you violated condition 2 when on or about November 6th, November 14th, November 24th, November 25th that you went to Indiana without permission. And then in count 8, you violated condition 4.6 when on about November 6th, November 14th, November 24th, and November 25th, that you violated probation when you had contact with Vida Celine. How do you plead to those violations? Mr. Burgett, how do you plead to those violations? Guilty or not guilty?
Guilty.
Okay. I would accept your plea, find that they're voluntarily and understandably made with the assistance of your attorney, Mr. Hogue, and a sufficient factual and jurisdictional basis. Would you agree there's a proper basis for the pleas?
Yes, Your Honor, there has been a proper basis maintained.
All right. In reference to sentencing, Agent Cornwell, did you want to proceed today, or did you want to set sentencing out?
I am ready to proceed.
We're as ready as well, Your Honor.
All right. Mr. Burgett, then I'm going to have Agent Cornwell give us her recommendations. I'll hear from your attorney, Mr. Hogue, and then I'll give you a chance as well to make a statement on your behalf. Agent Cornwell.
Thank you, Your Honor. Mr. Burgett was sentenced to a 3-year term of probation on June 23rd, 2023 for assault with intent, degree bodily harm less than murder or by strangulation. This is Mr. Burgett's 4th probation violation. He was living with Violet Celine in Indiana. He went to a court proceeding and notified them that he was living down there and that they were a successful family that had employment, and he was living with the children, and that kicked off a CPS investigation, which brings us to where we are today. This is the 2nd time he's been around children and not supposed to be, according to his conditions of probation. This is very concerning. I did look into a program for Mr. Burgett. And the VR staff program would be willing to consider him. There would have to be an order for this program. It's
And where is it located? Is it through MDLC?
yes, it is. It is.
Okay, and what program is that?
It's the VRSAP program, a sexual abuse prevention program. It is a lockdown facility.
So I guess the underlying charge was great bodily harm or like assault with great bodily harm with strangulation. I think that's what she said. And I'm assuming since he's not allowed to have contact with minor children, I'm assuming it happened in the vicinity of the children.
Okay. And so, in essence, you don't know if they would accept him into the program yet. Is that correct? We need an order to have him evaluated.
Yes. Yes. They did give a preliminary kind of, yes, we think he would qualify, but there would have to be a formal referral with a signed order from yourself, and then they can investigate it further to see if he'd qualify. I think that would be very helpful to Mr. Burgett. He seems to struggle with his initial crime. It was a sexual crime in nature. He denies it. He tells people he was not guilty of it. Even to the point where he's got Violet believing this and she has her kids around him. He's a pretty dangerous, honestly, person that needs to be rehabilitated and understand what he's done. I'm not sure if he has a cognitive delay or mental health or what else playing into this, but he refuses to take responsibility for what he's done in his life. If you notice, even in today, it was a lot of pointing the finger at this person or that person that's caused him to be here today, where in fact it is just his fault. And this is where we're at. So, the program would be very suitable for him. That would be my recommendation.
Well, it sounds like we need to actually reset sentencing because we should at least have an evaluation done before sentencing. I mean, if we can set sentencing up, you know how long it takes to have the evaluation completed?
It's not an evaluation. They just need an order signed by the judge, and then they can see if he'd be eligible for the program fully.
Okay. What if they say he's not eligible?
Look at other options. One of the problems with the program is there are short clinicians currently. So it depends how many people are in the program at the time, and so that plays a factor into it as well.
So then my thing is, should we do an order? I mean, do they need an order ordering him into it? What is it that they need
Yes.
in the course?
They do. They need an order ordering him into the VRSA.
Okay, and that's the same program I think that we talked about in your case, right? Okay.
Correct, Judge.
Okay. All right, Attorney Hogue.
Well, Your Honor, I spoke with my client. My client is, I understand what Agent Cornwell feels, but I think what we've all said here, and Mr. Brigette is taking responsibility for the violations that he has here. I think that this is an area of very convoluted gray because, again, we have an individual that seems to wish to engage into the probation. However, I think life is getting in the way and causing some unnecessarily eventful issues that is impacting his long-term accessibility in the probation. I've spoken to my client. My client indicates that he's willing to open himself to any type of programming that Agent Cornwell is willing to recommend. If she believes that this is going to be the most, I guess, useful, I guess, placement, then I feel that I guess that's a court's discretion. But at this point, I look at this, and there's a situation where he's not been alleged to commit any additional crimes. He's had contact with individuals that he's been restricted from. He spent the last 28 days incarcerated. Your Honor, I think the court has his attention. What I would request at this point, until we can get a green light from this VRSAT program, I would request that my client be allowed to at least be released from incarceration, to at least attempt to start getting his life back in order. It sounds like he's responsible for having a safe environment to live in. He's also needs to have gainful employment as well. So I think there's a lot of things on his plate at this time. But again, I just request the court, Your Honor, to take these items, or at least these allegations, these violations, at the weight that they deserve. Again, I understand some of these things are very clear. My client has violated the terms of probation, and again, these terms are put in place to make him successful. And I think that understanding that if he does comply with those, he won't be in jail. And with talking with him today, I mean, he's very worked up. A lot of anxiety, being in a place where it's not very stimulating as a human to be incarcerated. I mean, let's just put it, the facts as the facts they are. I think the court and both his probation officer has his attention at this point. I hear this is his fourth violation, and I've even indicated to my client that, look, you do too many more of these, and there's a very straight possibility that you don't get another chance. You don't get a slap on the wrist, but you get a free pass straight to prison. So I think with that information put forward, Your Honor, I would just request the court to impose the appropriate sanctions this time.
Thank you. Mr. Brigette, is there anything that you want to say on your own behalf?
Yeah, I'm sorry for messing up. Yeah, I can beg and plead to have one last chance. Yeah, trying to bring in work, trying to better myself for what I can be, and I know that I can be. And when the crowds brought me to the courts and to state Michigan via the courts, that if I ever end up getting in front of you again, I'll take the responsibility of all actions that I made at that point in time. At this point, that's have my attention on what I've done wrong, and like I said, I apologize to anyone.
All right. Yeah. All right. Mr. Brigette, I heard what you said today. I heard what your attorney said today. My concern is we were here on a violation basically almost a year ago, involving the exact same thing. When in January of last year, you were found to be in a romantic dating relationship with Violet Celine, and also that she had custody of the children. Back then, we continued your probation. I reiterated that you're not to have any contact, and you told me the same things back then, that you would comply. Here we are a year later, and we have the exact same violations, in that you're involved with a relationship with the same individual, and her children. And so I think the recommendation of the probation agent is appropriate. I gave you the opportunity as your attorney indicated here, we gave you the opportunity to be a man of your word. And here we are again today to violate. So I'll go ahead and continue your probation, but we'll provide that you be placed in the BRSAPP program.
And now, because of him and Violet, CPS is involved in those children's lives, hopefully forever. Because I'm sorry, but any mother that allows this to reoccur in front of her children needs CPS involved. I think that mother should be facing charges as well.
as recommended by the agent to the Michigan Department of Corrections, and give you credit for any time you are served. Let me ask you, Ms. Cornell, do you know when he can be transferred to the program?
Once I get the order, I could get it right over to them. They didn't give me a time frame, but I would assume it would be 2 weeks or less. It's the holidays, so.
You say he's been in how long?
28 days this time.
Okay. In addition, as a violation, I'll already serve 30 days, or excuse me, 50 days in the Cass County Jail with credit for 28. But that you can be released at the recommendation of the probation agent into the VRSAPP program. And while you're in the program, you'll receive credit against any additional jail time that the court has ordered. So we'll go ahead and leave it at that. Mr. Burgett, I will advise you have the right to appeal your sentence or conviction. If you do wish to appeal your sentence or conviction, could not afford an attorney, you could request a court-appointed attorney to represent you at public expense. Any request for an attorney must be made within 42 days of today's date. And I see that the deputy there has provided you with notice of your appellate right to review. You'll receive 2 copies of that, one for your records, one to return to the court if you wish to request a court-appointed counsel. Again, make sure if you did request that to be filed within 42 days of today's date. Attorney Hogan, anything further?
Nothing else, Your Honor. Thank you.
All right. Agent Cornwell, anything further?
No, Your Honor, thank you.
All right. We'll go ahead and hear it now. Are you Miss King?
Yes.
All right, we'll go on record here. Files 22-10037 FH, 24-10001 FH. People say Michigan versus Julie Murray King. Miss King, you're here for a violation. You're here on 2 warrants. One is a bench warrant for failing to appear at a probation violation hearing that was previously scheduled on October 20th. And so we'll go over that violation. Your probation agent, Michelle Cornwell, is present. She's indicated that you violated condition 1 of your probation when you failed to report to probation on September 3rd. Also, in count 2, that you violated conditions 3.4 when you failed to attend MRT on September 16th. In count 3, that you violated condition 2.4 when you tested positive for methamphetamine on September 17th. Count 4, that you violated condition 2.8 when you failed to attend substance abuse treatment on September 19th. And in count 5, you violated condition 2.0 when you violated probation when you possessed alcohol on October 13th, 2025. And then in count 6, that you violated condition 3 when you failed to report to your probation agent on October 7th of 2025 or any time thereafter. So in reference to those violations, those are the violations that have been filed. You currently are on probation in this court on a charge of possession of methamphetamine. Again, in that matter, if you were to admit the violations here today or you found guilty of the violations, the court could revoke any probation that's been imposed and can order that you be sentenced to a term of incarceration up to 10 years in the state prison. You understand that? Okay, now your Attorney Feldman is here for the arraignment, and Attorney Feldman, you indicated you did have a chance to discuss the charges with her.
I did, Your Honor. She's asked a couple of things to be looked into for regarding the treatment she was at and some issues that surrounded that. So we'd asked that a not guilty plea enter her behalf on those files and matter be set over for hearing.
And how long do you need?
14 days.
Okay. All right, Ms. King, I'm going to go ahead and request your attorney schedule any hearing in this matter for 14 days out or so. We'll get you back prior to that, or on that date. We'll get a date to your attorney, and we'll see you back in 14 days or thereabouts. Go ahead.
I don't know where she's going out. Failing to see how group this. I don't know how long that. I don't know how long that or no drug that's with her. I don't know where the group.
Miss King, Miss.
I can't see, but I can only imagine she doesn't have any teeth. If you didn't hear, she said, I didn't fail no alcohol test. But it sounded like.
King, that's why your attorney's asked for an adjournment, so that he can get that information. You know. Okay, all right. So, and that's what your attorney will come back in 14 days, thereabouts, and if there is proof of that, she'll have provided that to your attorney, and then we can address it at the hearing. Okay. Okay, thank you, sir. You're welcome. So, I need part of reason. Well, I was going to address bond, and we had you at no bond right now because of the failure to appear. So I'll address bond. Let me just, before I turn to you, Attorney Feldman. Agent Cornwell, you've indicated as part of your probation violation that she had failed to report to you. So why don't you follow up on that and give me some information?
Sure, Your Honor. She failed to report on October. Well, she went into a program, and then she bought the program. It was the Sacred Heart program, and she was to report right after leaving. She discharged herself the evening of October 7th, and she hasn't been seen reported to me since it was before October 1st. So, actually, October 1st, she did a video call to me, but she was not authorized to do a video call. Video calls are for people that are in compliance with probation and doing well on probation. Ms. King was testing positive for methamphetamine. She also had a scream device on her ankle, and I don't know where that is. It stopped connecting on the 3rd of October, I believe. But she has never reported since leaving Sacred Heart. I would be opposed to that. She's been given a lot of opportunities here. And her pattern is when it's time for court from testing positive, then we have court, then she admits herself, then she discharges herself the day after court without following the program or staying in the program. She's just been there a day or so, and then she absconds. And this is the 3rd time I think she's absconded. And she even had that scram device on this time. So I did go to her house. I found a still, I guess, making whiskey or something. I don't know much about that stuff, but she was not there. I could not find her. People that have been at her house are testing positive for methamphetamine.
She was just using the still to make distilled water. Maybe she needed it for her CPAP. It really wasn't for alcohol.
So I would be opposed to for Miss King.
All right. Your Honor, the limited I know about Miss King is that she's been a resident in Cass County for well over a decade. And I know that she has, in the past, made honest attempts to get to rehab. I believe she was removed from rehab this time because of a medical condition. It's one of the things she's asked me to look into for her. So we actually take those factors into consideration. All right. Well, my concern is obviously she's been on probation. This is an older file. And she did Sacred Heart. Again, it could have been for some medical reason. It was very shortly after she went in. There was also a court did order that she be placed on screen and tethered at a 3rd violation of her probation. And apparently that screen tether has been removed as well. And so what I'm going to do is I'm going to order no bond pending our next hearing. So we'll go ahead and continue here with no bond. And we'll see you back in 2 weeks, Miss King. Here.
In misdemeanor level cases, I am going to ask for a plea of either guilty or not guilty. If you plead not guilty, the court will set your bail and schedule further proceedings. If you plead guilty, there won't be any trial of any kind. You'd be waiving the rights that were read to you before, and your case would likely resolve today. Do you understand what happens if you plead guilty?
Yes, Your Honor.
Do you understand what happens if you plead not guilty?
Yes, Your Honor.
With respect to count 1, preventing arrest, class A misdemeanor, to that count, how do you plead, guilty or not guilty?
Guilty.
With respect to count 2, domestic violence, to that charge, how do you plead, guilty or not guilty?
Guilty.
With respect to count 3, disorderly conduct, to that charge, how do you plead, guilty or not guilty?
Guilty.
Do you understand that you have the right to plead guilty or not guilty?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving all the rights that were read to you before, and you're waiving specifically the right to a trial of any kind to a judge or a jury? In this case, because it involves an A misdemeanor, a default jury of 6, but you could demand a jury of 12. All jurors in a jury trial would unanimously have to find you guilty before you could be found guilty and punished. By pleading guilty, you're waiving the presumption of innocence and the requirement that the state prove you guilty beyond a reasonable doubt. You're waiving the right to confront and cross-examine witnesses against you. You're waiving the right to remain silent or to testify for yourself. You're waiving the right to present witnesses and evidence on your behalf and to use the court's subpoena power to force those witnesses to appear. You're waiving any and all defenses that you could have had. You're waiving all non-jurisdictional defects in the case, if there are any, and you're limiting your ability to appeal the case if you enter an unconditional guilty plea. Do you understand all the rights that you're waiving by pleading guilty?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Are you pleading guilty because someone has forced you, threatened you, or coerced you, or in any way made any promises to you in order to get you to plead guilty?
No, Your Honor.
Are you pleading guilty freely, knowingly, voluntarily, and intelligently?
Yes.
Do you need any additional time to speak with a lawyer about your rights, any potential defenses, the pleas you intend to offer, and the potential for the court to sentence you?
No, Your Honor.
Is there a plea agreement or plea negotiations that have taken place?
There was there was one from the attorney.
And do you understand that I don't have to follow that agreement? That's simply a recommendation to the court, and I'm free to impose whatever sentence I want, and it could be harsher than what you expect. And if it was harsher, you wouldn't be allowed to withdraw your plea and have a trial saying that isn't the agreement.
Yes, Your Honor.
And do you still want to plead guilty knowing that I don't have to follow a sentencing recommendation that's been put in front of you?
Yes, Your Honor.
And again, you've pled guilty to counts 1, 2, and 3. That's still your choice?
Yes.
Factual basis, Mr. Fremden.
Your Honor, this incident occurred 4 days ago in the city of Jamestown. When police arrived, they encountered 3 people, Aaron, his sister, Angel, and the defendant. The defendant had blood on her, but apparently no injuries. Aaron had blood on him and injuries. The defendant acknowledged she hit Aaron. Sister Angel said she had it on video and that the defendant hit Aaron dozens of times. Aaron maintained, we were just sparring. There was no domestic violence. He doesn't want her charged. Angel said this goes on too often and wants her charged. Police arrested her for domestic violence. She screamed, help me, help me. It's midnight on Christmas night. Another call came in because of the screams for help while they were trying to make the arrest for the domestic violence as part of the disorderly conduct. She also resisted physically getting put in the car. They ended up, she'd stick her leg outside, kick the inside of the car. They put her in the wrap, to successfully get the arrest done. The sister tried to intervene during the defendant hitting the brother, and when she tried to intervene, the defendant pushed the sister to the ground. The sister had abrasions or bruises on her elbows. That's all.
What
Your
is the
Honor, may I say
relation?
something?
You're going to get an opportunity, but I have some
Okay.
questions for Mr. Fremgen, yeah?
Okay.
All right, so what is the relationship between Aaron S. and the defendant?
There was something in the probable cause statement along the lines of in a dating relationship. I don't remember the exact phrase without looking at it, but I did check for that element.
All right, so dating relationship, but you're not alleging an intimate domestic partner, which would trigger the minimum mandatory.
Right. The department doesn't address that leg of the statute. I think I can say accurately ever. They just don't pick it up and look at it or report it.
All right, and by department, you mean JPD?
JPD.
Gotcha, okay. One last question, Mr. Fremgen. Why am I seeing this trailer today, 4 days after the fact, when under Belinsky, there's a requirement that we see a defendant within 48 hours. I understand this happened on Christmas, but court was open on the 26th. It's now the 29th.
Uh-oh.
Why didn't we see her earlier when she was arrested on the 25th?
As far as the court being open on the 26th, my impression was that the courthouse was locked because the county gave the county employees that day off. We're certainly willing to work with the court to make arrangements for opening the court more thoroughly on these sorts of occasions. Is that what the court's looking for?
Well, I just can't wait 4 days to have a probable cause determination and an initial appearance. And I think you know that. So it is what it is. It happened here. The question is, how do I stop it from happening in the future? And is there anything I should do about it in this case? The defendant has pleaded guilty. I haven't accepted her pleas yet. And I don't know what the nature of your plea agreement or sentencing recommendation is, but I'm a little nonplussed by the fact that we did not have an initial appearance to set bail and make a probable cause determination within 48 hours, which is required under long established U.S. Supreme Court case law, and as recently as 2022 in State v. Belinsky.
Well, my expectation, I haven't verified this, but the department has been good at this. When there's going to be a person held for more than 48 hours, they call a judge and give oral probable cause. I assume that happened in this instance. I don't check that because they're very good at it. And then again, we're willing to meet with the judiciary to come up with a solution to 4-day holidays. They do occur.
Okay, but what are you going to do about this case where this defendant's rights were violated?
And they are foreseeable. We'll be happy to work on a solution to that problem with the judiciary.
Well, and I think this case is going to get referred to Judge Narum, and we're going to need to set that up. So expect, Mr. Fremgen, that someone from the judiciary will be contacting you about it, and also contacting JPD leadership, because this just can't happen. So thank you for that explanation. Ms. Traylor, I told you that I'd give you an opportunity to speak. First, is that what happened?
Can I just get I just want to clarify that Angel is not Aaron's sister. It's his 18-year-old cousin that was uninvited. But besides that, I have the plea, like not the plea agreement, which I know you can go against, but it hasn't been mentioned at all in this. So I was wondering if, why do I have this here and you, because it says, for number two, charge two, the domestic violence would be dismissed in exchange for guilty plea of count three, which is the disorderly. Do you have any of that?
I have what's been presented to me in court.
Okay,
So
well,
you're-
this is what they said that my plea agreement from the state's attorney was going to be. And I know you can change it however you want, but I just don't understand.
All right, so I haven't accepted a plea. Mr. Fremgen, is there an agreement to dismiss a count?
Well, we've made a recommendation and sent it to her in writing, which is if she pleads guilty to one, count three. If she pleads guilty to count three, we'll dismiss counts 1 and 2.
Wouldn't it have been helpful to get that to the judge? I think Mr. Fremgren has failed on multiple aspects of this particular hearing, at least.
On occasion, this happens where a person pleads guilty to the whole slew of them. And typically I wait till the court asks for the state sentence recommendation to say our recommendation is dismissing 2 of the 3 counts and straighten it out at that point.
All right.
I suppose I got ahead of myself.
So does that answer your question, Ms. Traylor?
Yes, Your Honor. Yes, Your Honor, it does.
All right. Anything else with respect to whether or not what was alleged in the factual basis occurred or not?
No.
All right. I'm going to accept the guilty pleas that have been offered and find the same freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support the pleas as they were offered. Mr. Fremgen, the state sentencing recommendation.
Thank you, Your Honor. Again, our recommendation is to dismiss count 1 and 2. We'll move to do that now. And on count 3, a B misdemeanor, disorderly conduct, pretty much encompassing most of the people, the neighbor who called the cops, the niece, uninvited, and even the uncooperative significant other. 30 days at the Susquehanna County Correctional Center, 26 days suspended, 4 days credit for time served, unsupervised probation for 360 days, no criminal convictions, no possession of firearms, dangerous weapons, destructive devices. She does have several prior misdemeanor convictions, including, I believe it's crimes of violence. We'll get to that if there's questions. Fingerprinting today, $250 in fees paid at a rate of $50 a month. That's all.
Ms. Taylor, do you have a sentencing recommendation for me?
No, Your Honor. I just asked that if I do have to sit any jail time, if I could have some time to get my affairs in order, because I have 2 children.
All right. Mr. Fremgen, you mentioned some criminal history. Can you tell me what that is?
Yes, sir. Starts in 2018 with an MIP, 2 misdemeanor trespassings, 1 in 24 and 1 in 25 in municipal court, 2 disorderly conducts in 25 and a failure to halt in 25. So 2025 has been a pretty bad year for her, 4 or 5 convictions.
All right. You mentioned crimes of violence.
I said that reservedly. Mentally, I think I over categorized trespassing and disorderly.
How do you mix that up? How do you tell a judge that she has crimes of violence and then later on realize, oh, it was just trespass and disorderly conduct? You, sir, you are not doing your job very well tonight.
All right. Ma'am, is there anything else that you want to tell me before I impose sentence?
Honestly, all this happened because I'm drinking. So other than that, I'm not too disorderly. So
Anything else you want to tell me?
no, Your Honor.
And you're saying you have a drinking problem?
Uh, yes.
Okay. What are you doing to address your drinking problem?
I have, I've, I stopped going out. I stopped essentially drinking altogether. Christmas was just, you know, a bad day, no family around. And so I have a problem with once I start, I can't stop. It's not that I drink every day or whatever. It's just, and then, yeah, once I get too drunk, I black out and I become violent and disorderly.
Anything else?
No, Your Honor.
All right. Court's considered sentencing factors set forth in North Dakota Century Code Section 12.1, 3204. Sentences as follows. 30 days, and the sentence is on count 3 only. Counts 1 and 2, the state has moved to dismiss. The court grants the motion on counts 1 and 2 to dismiss those counts. The court directs the clerk to include on the judgment a notation that those were dismissed as part of a plea agreement. So those are not non-conviction records that would result in those records being restricted at a future time. They were dismissed as part of plea negotiations and a plea agreement. Those are not non-conviction records. So if you can note that in the judgment, the proposed judgment, the court would appreciate it. Counts 1 and 2 are dismissed. Count 3. Sentences as follows: 30 days, Stutsman County Correctional Center, first to serve 4 days. Credit 4 days, actual 0 days good time credit as of December 29, 2025. Balance suspended for a period of 360 days. Defendant shall be placed on 360 days of unsupervised probation, conditioned upon the following: defendant to not possess firearms or ammunition or other dangerous weapons or destructive devices. The defendant to submit fingerprints for inclusion in law enforcement's databases before release. The defendant to pay a $125 criminal administrative fee, a $100 facility improvement fee, $25 victim witness fee. The defendant must obtain from a licensed addiction counselor a chemical dependency assessment within 60 days of today's date. Defendant must provide proof that she has obtained that evaluation and file proof of its completion within 60 days of today's date. The defendant shall contact a licensed addiction counselor within 7 days of today's date to schedule that evaluation to occur within 60 days. That evaluation must again be completed within 60 days, and the defendant shall file proof of completion within 60 days. Defendant shall participate in, and successfully complete any recommended follow-up treatment from the chemical dependency assessment within 11 months of today's date, and file proof of completion that the recommended follow-up has been completed, again within 11 months of today's date. Do you have any questions, Mr. Fremgen?
No, thank you.
Do you have any questions, Ms. Taylor?
So those were 30 days suspended, right? Or do
The
I have to
sum
sit
and
30
substance,
days?
no, the sum and substance of my sentence is this: you have served all the jail that you're going to serve as long as you follow the terms and conditions of probation. The terms and conditions of probation are: stay out of trouble,
You have,
don't possess guns or ammunition, submit fingerprints before you go, pay the $250 in court fees. I'll allow you to set up a payment plan at a minimum rate of $50 a month starting February 1, 2026 with like minimum payments of at least $50 a month, payable on or before the first of every month thereafter until paid in full. So you got to pay the $250, $50 a month at a time, starting in February. You have to, within 7 days of today's date, contact a licensed addiction counselor and set up an evaluation for your drinking problem. You need to do the evaluation within 60 days. You need to file proof that you've done the eval. So a letter from the evaluator within 60 days, you have to file that with the court. And then within 11 months of today's date, you need to finish any recommended treatment and then file proof that you've done the treatment. So within 7, you have to schedule the appointment. You have to do the appointment within 60. You have to file proof that you've got the eval within 60. You need to do the recommended treatment, and then you need to file proof that you've done the treatment within 11 months of today's date. If you do those things, you won't serve any additional jail with respect to this matter. If you don't do those things, the state can seek to revoke your probation, and then the court can impose additional penalties up to the remaining 26 days in jail. So you don't want to do that. Do what you're supposed to.
Sounds good.
Understood?
Yes, Your Honor.
Anything I missed, Mr. Fremgen?
No, thank you.
This matter is adjourned.
This matter is adjourned, but it's not over because that judge is going to forward this case on because of the violations that occurred. So that prosecutor, he's going to have to answer for everything that went on here. Now, I do need to give a warning on the next case. There is a moment where one of the charges is relayed, and it does involve an animal. I am giving this warning because I know Auntie M very much does not like hearing that. It is mentioned once. It is not mentioned again. But it's necessary for the context of the case. But no one's gonna like this woman.
All right. Next matter is the court's going to take up. There's a couple of bond hearings. First matter is State of North Dakota versus Eliza K. Potratz, 47, 2025, CR 497. Ms. Chisholm appears on behalf of the defendant by reliable electronic means. Mr. Fremgen appears on behalf of the state in person. Am I pronouncing your name correctly? Is it Ms. Potratz?
Yes.
Ms. Potratz appears personally in the courtroom. Without her attorney appears by reliable electronic means. This is a Class A misdemeanor. There is a request for a bail review concerning a no contact provision. Bail was originally set on November 25, 2025, record index 13. There was a request for a bail review, looks like on the 26th of November. There were several letters that were filed with the court. On the 11th of December, there was an order denying bail reduction, record index 32. In that case, Judge Schockman had a bail hearing on December 11. It looks like for some reason it's dated December 11, 2026, but clearly that date hasn't happened. That's a typographical error. Judge Schockman denied the request at that point. 5 days later, there was a request for a fitness to proceed examination. Judge Narum signed that order. No fitness to proceed report has been received. On December 23, 2025, the court received a letter purportedly from the defendant requesting a bail review. It doesn't necessarily look like that letter came through counsel, and it also doesn't appear to be signed, but we are here for a bail review. Ms. Chisholm, go ahead.
Thank you, Your Honor. As the court correctly noted, we are asking the court to amend the bond order, lifting the no contact order, which in essence prevents my client from having contact with her minor child. We're also asking the court to consider amending the bail order to allow my client to travel outside of the state of North Dakota so that she may attend her oldest daughter's hockey games, which sometimes occur out of state in places such as Maryland and other places across the country. Thank you.
Mr. Fremgen.
Thank you. I think that as far as I know, there's been no change in circumstances since the 11th of December when this same request was made to allow contact with the 9-year-old. The state did file for the psychiatric evaluation the day after the charges were signed. I think Judge Narum waited the 14 days or so and then signed the order more recently. Disclosure went out to the state hospital in part today, electronically, with a disc going out in mail this afternoon to the state hospital. This is a case where the defendant was having some sort of a psychological issue. She had been walking in the neighborhood, I think more than once without her top on. And then in the day that the animal abuse charges for stabbing the family dog, and there was repeated stab wounds on the dog that was done in front of the 9-year-old child. We asked the judge, and I believe the bail order allows for telephonic contact. So it's a little bit different than the no contact order prevents my client from having contact with her children or her child. Looking at the bail order, it says may visit via phone. So it's just a proximity with a state witness issue or bar that precludes the defendant from being within 300 feet of the 9-year-old.
So she can talk to her 9-year-old via phone, but she's requesting simultaneously, after a judge has already denied the request, she immediately filed again that she wants to have visitation, to have the restriction removed so that she can have physical contact with her daughter. And simultaneously, she's asking them to lift travel restrictions. That's kind of an interesting pair. I don't trust her.
So we think that's reasonable under the circumstances and ask that it stay in place.
First off, Mr. Fremgen, there were two requests. One dealt with the child, the other was the travel restriction. Do you take a position on the travel restriction?
No, I don't really think that that's an issue for me. I think she's going to land back here. She's a lifelong Jamestown resident. If she leaves, I don't expect her to try and stay away to avoid proceedings.
All right. Ms. Chisholm, any follow-up?
Yes, just briefly, Your Honor. I think there has been a change in circumstances. Since the last time we were in court, there has been an active divorce proceeding that has started. My client has been now out of the home for 30 days. She's been living in a hotel, incurring charges that, quite frankly, she can't afford. and she's been cooperating with Child Protective Services in this matter. She has shown that she's been able to manage her mental health adequately. She's willing to cooperate with the fitness to proceed evaluation. I don't believe that there is a necessity in the no contact order. I understand the state's issue with respect to the witness, but this is a child and a parent, and I think that outweighs any concern the state would have as far as a witness issue, as far as persuading any witnesses. And in this particular matter, Your Honor, I think the psychological harm that this is causing the child from not having contact with a parent far outweighs any concern that the state would have as far as manipulating any witnesses. And for that reason, Your Honor, we would ask that the court consider amending the bond as requested. Thank you.
Ms. Potratz, you don't have to say anything, but I'll give you an opportunity to weigh in if you'd like. I will remind you that this is a recorded proceeding, and anything you say can and will be used against you. Again, you have the absolute right to remain silent. You don't have to say anything. If you choose to remain silent, that will not be used against you in any way. If you choose to waive your right to remain silent and provide a statement to me, just understand that Mr. Fremgen might be able to get a transcript and use that statement against you. So I would require and request that you limit any contact or any communications to me to address the bail request that you're asking me to consider.
You know, normally I would be concerned about defendants speaking and concerned they might say something that could be used against them, but after the performance we've seen of prosecuting attorney Fremgren here, she could flat out admit to multiple crimes on the record, and I don't think that this man's going to put in any effort to prosecute the case. So we'll see.
Do you understand that, ma'am?
I do.
Is there anything you want me to know before I make a decision?
The only thing I'd like you guys to know is that I was contacted about the eval and everything has been scheduled. And there has been more evaluations scheduled. So it's just in timing, but that was all. In regards to Mr. Friedman and what he had, it was to be done right away, I believe. I can't remember what he said, but the state hospital contacted. I wasn't aware that I was to contact them, so I do apologize. It's scheduled. That's all.
All right, the court's considered the constitutional provisions concerning bail. The court's considered Rule 46. This is a review hearing. Bail is already set at $1,000 cash with additional conditions. The conditions Ms. Potratz is asking the court to consider amending concern a restriction on her ability to have contact directly or indirectly with Potratz, who appears to be Ms. Potratz's daughter. I am going to, well, the second condition dealt with a travel restriction. The state did not oppose any lifting a travel restriction under the facts and circumstances of the case. The state does appear to oppose any modification or amendment to the restriction prohibiting Ms. Potratz from communicating in person with the child. I am going to amend bail as follows. Bail will be amended in a couple of respects. The court finds and concludes that cash-only bail is unconstitutional. I have on numerous occasions. I'm going to amend bail to just simply offer an alternative. I understand bail has already been posted and Ms. Potratz is not in custody. Bail will be amended to $1,500 cash, or in the alternative at the defendant's option, $5,000 corporate surety. Additional conditions: you shall not violate the laws of any city, county, state, or nation. You shall be employed, actively seeking employment, or pursuing a course of study. I am not going to amend the restriction prohibiting the defendant from coming within 300 feet of the alleged victim. And Mr. Fremgen, what is EP's date of birth and middle initial? I would prefer to use initials and date of birth rather than a full name in a public document.
I'm going to check the confidential information form that we should have filed in this case for the date of birth. Doesn't have anything. I'll check the report. I understand the court's preference for initials. The police department unfortunately has a position where they feel uncomfortable trying to arrest somebody for violating a no contact order if there are only initials there. So I understand the DOB, which is 06, and the middle name is RAE, Romeo Alpha Echo.
All right. So, Ms. Potratz, you understand who ERP, date of birth, is, right?
I do.
And you understand that you are prohibited from having in-person contact with that person, right?
Yes.
And you understand that you are allowed to contact that person by telephone only, right?
Yes.
And do you understand that if you have in-person contact or come within 300 feet of ERP, that you can be arrested and charged with a crime?
Yes.
And you can be held in contempt of court for intentionally violating the court's order. Do you understand that?
Yes.
I am going to lift the travel restriction. So paragraph 5 will be deleted. All other prior conditions will remain in the same form and effect. So you must maintain appropriate contact with your defense lawyer. You must notify the court of any change of address, employment, or phone number. You must sign a waiver of extradition if that's not already been done. You must not possess a firearm, disruptive device, or other dangerous weapon. You must personally appear for all scheduled court hearings and appearances unless excused, or a waiver of appearance is filed. Your next court date is March 18, 2026 at 9 a.m. in the Stutzman County Courthouse. There's a couple of reasons I chose not to amend paragraph 3. The first is, although there has been an argument that this condition is imposing psychological harm on the child, I didn't receive evidence of that. There is the fitness to proceed issue that is still outstanding, and the court hasn't been able to circle back on that issue. The court notes from the declaration in support of probable cause that the child was exposed to the alleged incident and suffered great harm from that incident. And the court is concerned that in-person communication with the defendant might cause further psychological harm. I understand Ms. Chisholm's argument that not being able to see her mother causes the same harm. I'm concerned for the opposite reason, that seeing her will cause the harm because it will trigger in her mind memories of the alleged incident, which as a 9-year-old are difficult for a 9-year-old to process. And so without some testimony or evidence to the contrary, I'm just unwilling at this point to change that provision. Judge Lefevre is the assigned judge. That was a condition he felt was appropriate. There was an order denying a bail reduction signed by Judge Schachman, so it has been reviewed more than once by 2 different judges, and both judges have concluded the same, that Judge Lefevre's condition was appropriate under the circumstances, not only to secure the defendant's appearance in court, but also to protect society and individuals in it, including ERP, date of birth. Any questions, Mr. Fremgen?
No, sir.
Any questions, Ms. Chisholm?
No, Your Honor, thank you.
And just so you understand, Ms. Potratz, keep in touch with your attorney. Your attorney is working for you. If these conditions need to be addressed, you can talk with your attorney about how to approach that again, but that's the court's decision for today. We are adjourned in this matter. Thank you.
Thank you.
What are we next, guys?
Next matters on my court docket include 3 either appearances on bench warrants or bond hearings relating to 24/7 violations. These fall in sort of a hybrid type of situation, so I'm going to read all 3 defendants the rights that apply to contempt proceedings, because that's essentially what this is. You have the right in a contempt proceeding to be informed of the nature of the proceeding against you. Contempt includes disobedience, resistance, or obstruction of court's authority, process, or order. The court must first determine whether or not remedial or punitive contempt sanctions are appropriate. For bail violations, the court generally considers remedial contempt proceedings appropriate. Remedial contempt includes the potential for penalties to include compensatory reimbursement of money, jail for as long as the contempt continues, or 6 months, whichever is less, a $2,000 a day forfeiture until the contempt ends, in order to ensure compliance with the court's previous order or any other sanction if the court finds those previous sanctions would be ineffectual in stopping continuing contempt. You have the right to be personally present in court. You have the right to reasonable notice of any allegations against you and in order to show cause. You have the right to bail if a warrant of attachment is used. You have the right to attorney representation. You have the right to privately retain an attorney. You have the right to represent yourself, and if jail is a potential consequence, you do have the right to a public defender. You have the right to reasonable delays to prepare for these proceedings. You have the right to an evidentiary hearing and an opportunity to be heard. The standard of proof and burden of persuasion rests with the state in this matter to prove by clear and convincing evidence that you willfully, intentionally, and inexcusably and unjustifiably committed a contemptuous offense. The defendant bears any burden to establish any defenses, including justification or impossibility. The rules of evidence apply in contempt proceedings, except summary contempt. This is different in a bail hearing. In a bail hearing, the rules of evidence do not apply. So this is one of those weird cases or weird situations where the rules conflict on whether or not the rules apply, and the court's going to afford the defendants the maximum protection possible, which means I'm going to treat it as though the rules apply. You have the right to confront and cross-examine witnesses against you. You have the right to testify or to remain silent. You have the right to present witnesses and evidence on your behalf and use the court subpoena power to force witnesses to appear. The next matter on the court's docket, State of North Dakota versus Cassie Lynette Belaires, 47-2025, CR 450. Ms. Depute appears by reliable electronic means. Ms. Belaires appears. Ms. Chisholm appears. In this case, looks like there has been, it's a Class B misdemeanor domestic violence bodily injury as a condition of bond. Back in October 27, 2025, bond was set at personal recognizance plus the 24/7 program. Thereafter, about a week later, there was a problem and an affidavit of probable cause was filed alleging a violation of the 24/7 program, record index 13. A warrant was issued. It was served a few days later. The court held a hearing, and on November 10, 2025, there was an order following a 24/7 violation, record index 20. About 3 weeks later, there was another affidavit of probable cause alleging another violation of the 24/7 program, record index 23. A warrant was issued on December 1, 2025. It was served on December 5, 2025, record index 26. Another violation affidavit was filed on the same date, December 5, 2025. Record index 27. The court issued on December 5 a second order for violation, or an order following a 24/7 violation, requiring the defendant to serve 3 days in jail. That is record index 28. On the 29th of December, record index 32, the court received multiple violation reports indicating that the defendant failed to appear as required for her twice per day 24/7 breath testing on December 25 in the morning, December 25 in the evening, December 26 in the morning. December 26 in the evening, December 27 in the morning, December 27 in the evening, December 28 in the morning, and thereafter, sometime on the 29th of December, Sergeant Jessica Hartman filed the request for a warrant. The court reviewed that request and signed it.
I turned myself in.
At about 1:11 this afternoon. Ms. Belair, do you understand why you're here?
Yes, because I missed my check-in on Christmas morning, and so I turned myself in today as soon as the courts were open.
Just Christmas morning?
Yeah, I missed from Christmas until now because it was a holiday weekend, and I was advised that the courts were closed. And having two small kids on Christmas break and whatnot, I felt like the most responsible thing to do would be to turn myself in first thing this morning, which is what I did. And then I have two advocates in the courtroom currently as well that can vouch that I was abiding by everything in the terms, with the exception of turning myself in for the holiday weekend.
So I'm going to stop you.
Go ahead,
I just
sir.
want to make sure
Yeah.
you understand. You have the right to an evidentiary hearing. At the evidentiary hearing, the state would be required to prove up that you violated the 24/7 program intentionally. And if you did, the court can find you in contempt and impose a penalty. Do you understand that?
Yes.
Okay, so you have the right to admit or deny the allegations. The allegation is that you did not participate in the 24/7 program from the day of Christmas, and you haven't participated until you turned yourself in. And was that sometime today?
That was this morning, yep.
Okay, so you didn't
First thing
test
Monday morning.
anytime between Christmas and now?
At home, but not at the police department. No, just because I was informed I would be detained.
All right.
And so I called my attorney and let her know.
Stop.
Okay,
Just, my question is, you admit that you did not participate in the 24/7 program from Christmas until this morning?
Yes, Your Honor. I do admit that.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to an evidentiary hearing?
No, Your Honor.
Court to find a knowing and voluntary admission to the allegations contained in the affidavit of probable cause for violations, record index 32. The warrant for the defendant's arrest, record index 33, is quashed. Ms. Depute, your thoughts on disposition?
The state is recommending a disposition of 1 day credit for 1 day served. In addition, this is related, but not necessarily the docket per se. An amendment to the bail order to allow for 24/7 breath testing or scram. The state's recommendation, to elucidate a bit, the defendant has a substantial number of previous violations. However, the non-appearance in this case, I do believe that she was testing at home. Specifically, in the past, the individual she's residing with had turned her in for consumption of alcohol for past violations. He came into our office. That same individual indicated that he had bought what I assume is the equivalent of PVT that has been testing her even when she wasn't going into the PVT testing. At every single juncture, there's been mention of a child with autism that's required additional care. In this particular case, I understand the rationale for missing the 25th. I think the 26th and 27th probably was not. The 28th wasn't justified, but I understand the rationale. Additional sanction isn't required. I believe, even though the defendant has pled or blown positive and had very high positive numbers as violations, I don't believe this is one of those cases, and additional incarceration isn't warranted. The amendment of the bail order, when bail was initially set, there was discussion about whether the defendant could afford it. She indicated that she could not, and so the original bail order provided only for 24/7. There's discussion with the victim who came into her office this afternoon or this morning, indicating that scram might work much better for her based on the time demands relative to her child. I would ask it to be presented as an or option if the defendant is able to come up with the money in some capacity. I know it's about $16 or $17 a day.
then I think there's no reason that she couldn't be on it.
Ms. Chisholm.
Thank you, Your Honor, and we would have no objection to the state's recommendation under the circumstances that the state has described.
Anything else?
No, Your Honor, and just to be clear, I did not have a conversation with my client. She did call and leave a message on the answering machine at my office on Christmas Day, but I did not have a conversation with my client outside of the message that she left on the answering machine. So I just want to be clear that I did not advise her to not turn herself in with respect to the 24/7 violation. Thank you.
Ms. Belair's, I'll give you the same warning I gave the previous person. You don't have to say anything. This is a criminal proceeding. At least the underlying matter is a criminal proceeding. So you have the right to remain silent. Anything you say can and will be used against you. You have the right to remain silent, and if you remain silent, that won't be used against you in any way. But if you choose to make a statement, understand that Ms. DePute can use it against you. She can get a transcript of whatever you say and use it in court. Is there anything you want to tell me before I make a decision?
I also feel that bracelet would be extremely beneficial to me, and I have gotten the money together this weekend to pay for it, just to help alleviate any possibility of this occurring in the future. Otherwise, I appreciate the court's time and like her recommendation, Your Honor.
All right. So addressing the contempt issue first, and then addressing the request to amend bail. Court finds the defendant willfully and intentionally and unjustifiably committed an act in violation of the court's bail order. The court finds the defendant in contempt of court. If this was a first offense, or if there weren't previous issues, my position on it would be rather different. The court finds the defendant made a conscious decision not to turn herself in, knowing that she violated the order, and chose not to turn herself in from Christmas until now because she didn't want to be arrested and held. So basically, the defendant knew she had a court order telling her she had to do this, and she chose not to do it, and chose not to appear in court, not to appear at the Stutzman County Correctional Center. Those were conscious decisions she made because she violated the order. I find credible Attorney Chisholm's statement that she did not provide legal advice to the defendant not to turn herself in. Nevertheless, the court finds that the defendant made a conscious choice not to turn herself in because she knew the consequences that would be coming. What that looks like to me is that the defendant is just choosing to say, I don't care what the judge says. I'm not going to do it because I don't want to get arrested. And that, frankly, is not the purpose of the bail order. The bail order warns defendants, and it's not just this defendant, it warns all defendants that if you violate the order, you can be held in contempt of court, and the court can modify bail at any time with or without notice. So then the question falls, what's the appropriate sanction? Here, the court finds the appropriate sanction. What I really want to do is say, you missed 5 days of testing. I'm going to hold you in jail for 5 days because I have to presume that you were using the entire time. That's what I want to do. Because that's, frankly, I think, an adequate and fair punishment when a person willfully and intentionally violates the court's order, not once, not twice, but 3, 4, 5 times. Here, there's at least 3 affidavits saying the defendant violated the order, and the last affidavit includes a total of 5 days. 5 days worth of violations, or 4 days worth of violations. That's what I want to do. I understand this is a misdemeanor level offense, and generally we don't hold people in custody on misdemeanor level offenses unless there's an adequate and appropriate reason to do so. But intentionally disregarding a court's order looks a whole lot like disrespect to the court, and that, by definition, is contemptuous. Sentence is as follows. For contempt, this is a remedial sentence. 1 day in the custody of Stutzman County Correctional Center. The defendant surrendered herself at what time, ma'am? Ma'am, what time did you surrender yourself?
Me, 10 o'clock.
The defendant can be
As soon as
released
I got
at
my son off. I'm sorry.
the defendant can be released at 10 a.m. Central Standard Time on December 30, 2025. Credit since 10 a.m. December 29, 2025. Now turning to the bail amendment question. This is a Class B misdemeanor domestic violence. A 24/7 sobriety program has been put in place. Although it is a potential and the court is authorized to impose it, it is not a mandatory requirement. Bail is amended as follows. Bail will be amended to $1,500 unsecured appearance bond. Additional conditions: you shall not violate the laws of any city, county, state, or nation. You shall be employed or actively seeking employment or pursuing a course of study. You shall not leave the state of North Dakota without the advance express permission of the court. You must maintain appropriate contact with your defense lawyer. You must notify the court of any change of address, employment, phone number, or email address. You must not possess any alcohol or controlled substances except as authorized by a licensed physician. You must sign a waiver of extradition and promise to appear before release. You must not possess a firearm, destructive device, or other dangerous weapon. Your next court date is February 18, 2026 at 9 a.m. in the Stutzman County Courthouse in Jamestown, North Dakota. You must personally appear for all scheduled court hearings and appearances unless excused by the court or by proper waiver of appearance filed by your attorney. So I am deleting the 24/7 sobriety program. It's not a mandatory condition. Here, clearly, it appears to the court as though the defendant has a significant alcohol problem. The court has imposed an alternative alcohol prohibition, but it is apparent to the court the defendant has been violating the 24/7 program pretty consistently throughout the proceedings. It's a waste of law enforcement's time. It's not necessary here. And the defendant appears to do what she wants. It looks like there's already, at this point, 7 days of credit that have been directly attributable to the 24/7 program. I'm just not inclined to continue to bring the defendant back before the court on 24/7 violations in a B misdemeanor where it's not required. That's the court's order.
So it's kind of sink or swim now. You no longer have the 24/7 program. So when you come back for violations, they're just straight up violations.
Ms. Depute, do you understand or do you have any questions?
No questions, Your Honor.
Ms. Chisholm, do you have any questions?
No, Your Honor. Thank you.
This matter is adjourned. Next matter is on the court's docket, State of North Dakota versus Tyson Lee Oberlander, files 47-2025 CR 399, 47-2025 CR 483. The defendant appears personally. You can have a seat, sir. Defendant appears personally by reliable electronic means. Attorney Scott Sadness appears on behalf of the defendant in file 399. Attorney Gonzalez appears on behalf of the state in both files. Mr. Sadness, do you also represent Mr. Oberlander on 483?
Just 399, Judge.
All right. Sir, were you present in court at the beginning of court when your rights were read?
Yes, sir.
Were you present in court when I explained the rights in 24/7 proceedings or contempt proceedings?
Yes, sir.
All right. So this case is a little bit different than the previous person's case in that there was a bench warrant issued in your case for failing to appear when required. So in your case, the court is not treating this as a bench warrant based on contempt, but rather a bench warrant issued due to your non-appearance. So I'll treat it just as a bail hearing. Mr. Gonzalez, go ahead.
As a bail hearing, Your Honor, before we get to that point, I do believe that there was some communication between my office personally and to defense counsel on the status of these cases. So I would have Mr. Scott Sanders speak on to that note, if it pleases the court.
All right. Mr. Sandness.
Your Honor, I did speak with Mr. Gonzalez about a possible disposition. There may be one in the works. I have not had a chance to speak with my client about that further. As I indicated, I only represent him on the one case. I'm not sure if he's still planning on putting in an application on that other case or wishing to represent himself. But I intend to proceed with the bond hearing today. I'll speak with my client after court and then advise him what the state's full recommendation is. And if he wishes to accept that, I can contact the court and schedule a further proceeding. So thank you.
All right, Mr. Oberlander, I'm going to address file 483. The court's notes indicate that on November 17, 2025, you appeared in court. Your rights were explained to you. With respect to an attorney, the notes say, quote, will apply, end quote. And then bond was set. And that, again, was back in November. You do have the right to an attorney in every proceeding, including this one. You have the right to hire a lawyer. You have the right to apply for a public defender. And if you financially qualify for one, the court will appoint one to you. Or you have the right to represent yourself. It looks like from the court's notes that Judge Lefevre allowed you to appear on your own, noting that you will apply for a public defender later. What is your position on your right to counsel in file 483?
I applied for a public defender.
So you applied in one file,
I
file
filled
ending
out the
399.
application today.
You filled out an application today.
Yes.
And I haven't seen that application, sir, but is it substantially different than the application you filed in 399?
No.
Has your financial circumstances changed since the court appointed you a public defender in 399?
No, sir.
Court will find the defendant indigent based on the application for a public defender in file 399 and file 483. The court will appoint public defense services. Mr. Sandness, I'm assuming that's going to be you, but I'm not going to presume that. For today's purposes, will you make an appearance on a special limited basis for Mr. Oberlander in file 483?
I will, Judge.
All right, the court will note that I am approving Mr. Oberlander's request for a public defender in file 483. And for today's purposes only, Mr. Sandness will make a special limited appearance on behalf of Mr. Oberlander for today's purposes in 483. Ultimately, it's up to the commission to determine whether or not Mr. Sandness will be appointed as Mr. Oberlander's long-term attorney in this file. But Mr. Oberlander, Mr. Sandness will represent you on both files today. Do you understand that, sir?
Yes, sir.
Do you have any other questions about your rights?
No, sir.
It sounds like Mr. Sandness has had conversations with Mr. Gonzalez about perhaps resolving your case, but it doesn't sound like that has been tied up yet. So he wants to move forward with simply a bail review today to address your non-appearance. Do you understand?
Yes, sir.
All right. So with that being said, Mr. Gonzalez, what are your thoughts on what I should do about bail in light of the non-appearance?
In light of the non-appearance, Your Honor, and I believe this is the second time in this is 399 file, and now we have this new 483 file. So just to address this one at a time, I believe this is the second time that he's failed to appear. His bench warrant amounts kept increasing from $500 to $1,000. The files 399, 483 are dealing with the same subject matter, meth and methamphetamine paraphernalia. I do not believe nor have any faith that if he were to get out on a non-secured bond that he would be able to return back to court when he's supposed to. He's already indicated and has shown that he is either unwilling or incapable of doing so. Given that, I'm asking for a $500 cash bond, or in the alternative, a $2,000 surety.
Mr. Sandness.
I spoke with Tyson. He indicates that he does not have the ability to post any funds at this time. Both parents are elderly and in poor health. Mom's in a nursing home, dad's in an assisted care facility, per my client's report. He acknowledges he's been struggling out in the community, Judge. He's had a hard time getting, permanent address.
Well, it does sound like his parents are both taken care of in nursing home type settings. That's a bonus. One of the few times that we won't hear he cares for his elderly parents as an excuse for bond.
His phone's often not with funds or not working. He indicated he still doesn't have a working phone. He did give me a new address in Jamestown. Asked him if he's employed. He said not currently. He did indicate he has applied for admission into the Firm Foundations, the sober living house, which I think is a good option for Tyson to pursue. So at this time, we're not able to post any cash bond. If the court would allow him to release, it'd have to be released on an unsecured appearance bond. Thank you.
Mr. Oberlander, what is your current address?
Jamestown, North Dakota.
Okay, Madam Clerk, did you catch that?
I did, Your Honor. Thank you.
All right. So, Mr. Oberlander, it looks like we've had problems getting you to show up in court. So your attorney is asking me to simply let you go. And this is now several times that you have not shown up when you were supposed to. It looks like you didn't show up on October 29, and the court, without issuing a warrant, simply continued the hearing. And then about a month later, on November 26, you didn't show up. Then the court issued a warrant, and now you sit a month later, you were finally apprehended. What's it going to take to get you to show up when you're supposed to?
I apparently my mailing address was not, I wasn't receiving my mail there. I do have this new address where I can receive my mail now. There was a time before that I was on bond that I signed in every morning at the sheriff's department. Is that a possibility?
So one of the conditions of bond was that you check in with your attorney on a weekly basis. I don't want you to tell me whether you've been doing that or not, but I'm going to tell you that I know Mr. Sandness, and I've known him for a long time. I know that he tells clients when they need to show up in court. So if you were in touch with Mr. Sandness, he would have told you when you needed to be in court, and you missed twice. And so now your case has been delayed at least 2 months, waiting for you to show up. And the only way you showed up was you were drug into custody in County Orange. What's it going to take to get you to show up? Because that's the primary purpose of bail, to ensure a defendant appears in court. What does it take to get you to show up?
Nothing more than knowing when my court dates are.
Well, I'm going to be really clear about when your court date is. Your next court date, sir, is January 21, 2026 at 9 a.m. in Stutsman County's courtroom number 1 in the Stutsman County Courthouse in Jamestown, North Dakota. So January 21, 2026, 9 a.m. Do you understand when you need to be next in court?
Yes, sir.
Do you have any questions about when you next need to be in court?
No, sir.
Is there going to be any excuse for you not appearing on January 21, 2026?
No, sir.
Do you understand what kind of consequences there will be if you don't appear on January 21?
Yes, sir.
Anything else you want to tell me about bail?
No, sir.
All right, so first,
it's hard to have contact with my mom from in here, and she's not doing very good. She did not recognize who I was the other day. She's got Alzheimer's.
all right, so The bench warrants that were issued on November 26, 2025 in both cases are quashed because they have been served. Bail is amended as follows for now. The court consolidates the bail into one file. I'm going to set bail at an amount of $100 cash, or in the alternative, $1,000 corporate surety, with the following additional conditions. The defendant shall not violate the laws of any city, county, state, or nation. The defendant shall not leave the state of North Dakota without the advanced express permission of the court. The defendant must maintain appropriate contact with his defense attorney on at least a weekly basis. You must notify the court of any change of address, employment, or phone number. You must not possess or consume any alcohol or controlled substances except as prescribed by a physician. You must sign a waiver of extradition and promise to appear. You must not possess a firearm, destructive device, or other dangerous weapon. You must personally appear for all scheduled court hearings and appearances unless excused by the court or by the filing of a proper waiver of appearance. Your next court date, again, January 21, 2026, 9 a.m., Stutsman County Courthouse, Jamestown, North Dakota.
The judge is going to make sure to ram that date home.
If you've already filled out an application form for court-appointed counsel, you won't need to fill out another one, but the court needs it. So if you filled that out, just make sure it gets filed. If you have not filled it out, then you will be required to fill out an application for court-appointed counsel before release. If you remain in custody for longer than 48 hours following today's hearing, you can request a bail review. Your attorney can help you with that. But simply put, sir, these are felony level cases. The purpose of bail is to ensure that you show up. The court has substantial concerns that you won't show up and that you have not been in touch with your attorney as required, which is why you have not shown up in court when you were required on October 29 or November 26. And so I'm requiring a very minimal amount of bail. It's still money, and I understand that for an indigent defendant, that can result in a person being held in custody longer than they would prefer. But here the court has substantial concerns that the defendant will not appear unless a modicum of financial bail is required. Any questions, Mr. Gonzalez?
No, Your Honor.
Any questions, Mr. Sandus?
No, Your Honor, thank you.
Any questions, Mr. Oberlander?
No, sir.
All right, these matters are adjourned.
Sorry, guys. At the very, very last moment, my daughter needed my attention for just a second. I know, but he's one of my favorite judges. I don't run him very often, though. It's possible. All right, guys, guess what? I got gifts in the mail. Gifty gifts. So I'm going to really quickly open them, and then I'm going to go to bed. Hopefully it's nothing I ordered and forgot. Because I had a whole bunch of other stuff turn up at the same time, but I knew what those items were. I don't know what these are. That's why I'm assuming they're gifts. There's a tag. There's a slip. It got away from me though. Okay. It says, Merry Christmas from Charlie. Charlie. He wasn't here tonight. He went to bed. It's stuck. Oh my, it's really stuck. Okay. Ooh, hey, it kind of matches the one that I've got on. I love it. I think he gave me way too much credit on my size, though. I don't know. I'm gonna have to try this one on. There's a tag. It doesn't say a size. Definitely gonna have to try this one on. I love the bright colors. Okay. And this feels just as squishy. Oh my gosh. That's gorgeous. And yes, now that I see the size on this one, he definitely gave me too much credit. Sometimes different sizes run, different. Maybe I'll be able to squeeze into it. If not, I'll have to exchange it for the exact same thing. Oh, this one looks like it might run a little bit more. I love it. It's got 3/4 sleeves. I love this pattern. This is so beautiful. And it's so soft. I love this. Oh my gosh, I love it so much. Merry Christmas. I hope you like these items as I know little about women's clothes. From Charlie. Charlie, you did great. They're beautiful. Oh, I love that white one. That is so soft. Oh, I don't have any more. I don't have any more. I know, that was so super sweet. I think the white one will. The multicolor one does look, it looks a little slim. I'll have to try it on. Hold on, guys. Hold on one second. Sorry, my daughter's home from school, so. Oh, guys, yes. Absolutely, we did. He's sleeping like a normal person these days. April's very tired. If y'all can't tell. And yeah, the judge's voice was putting April to sleep too. He sure is. I have been told. Have you listened to the songs? There's 2 versions. There's 2 versions of them. They're on Spotify. They're on Apple, the Apple Store. For the Apple Store, I only put them up for 99 cents. So, if you want to buy it and have it in your playlist, or you can just Spotify it. I'm not alone. Thank you so much, you guys. And thank you, Charlie. You guys are absolutely amazing. Hey, it's Jerry's birthday and I'm getting the presents. I love you all. You guys seriously make my life so wonderful. And what is Billy doing? Okay, now I can go. We had to enjoy Billy for a moment. Be safe, be well, sleep sweet, and much love.